Good afternoon, ladies and gentlemen. You don't seem to be in a talking mood. Well, let's move on. My name is Mpedi. I'm the Vice Dean at the Faculty of Law. I will be chairing this session, which is session 4 of our symposium. The theme for this session is building a global framework to facilitate trade and investment, South African and regional perspectives. There are 3 papers. Without any waste of time, the first paper will be by Professor C.F. Forsyth, and the title of the presentation is Southern African Private International Law and the Hague Principles. Ladies and gentlemen, Your Excellencies and ladies and gentlemen, Prof C.F. Forsyth is Professor of Private International Law and Administrative Law at Cambridge University. He is the doyen of conflicts lawyers in Southern Africa and the author of the leading textbook in the field. Case law in Southern Africa contains hundreds of references to his publication. Prof Forsyth is also a barrister of the Inner Temple with chambers in London, the director of the Center for Public Law and the African Studies Center at the University of Cambridge. Prof Forsyth, your textbook was prescribed to me when I was young, single, sexy student, so it's an honor for me to chair this session. I have to say this, the floor is yours.
I'm delighted to be here. When I started being involved with private international law in Southern Africa some 30 years ago, it was a tiny field. There were very few of us in it. It was only really me and Professor Addison Kahn. Now it is just wondrous to see so many students here today, to know how many students there are in South Africa studying this subject. Not only the numbers of students, but their enthusiasm. So I'm delighted to be here and to be delighted to be among such enthusiastic students. I want to start by saying something about the nature of Southern African private international. The foundations, and I think I've decided to ditch my presentation because we probably don't have time for everything, so the slides won't be moving on. The foundations of private international law for the 6 Roman Dutch jurisdictions, and only South Africa has been mentioned today, but there are 6 Roman Dutch jurisdictions in this neck of the woods: South Africa, Namibia, Botswana, Swaziland, Zimbabwe, and Lesotho. The foundations of their private international law were forged in the Republic of the United Netherlands in the 17th century in the writings of Ulrich Huber, Paul Foote, and Johannes Foote, to name simply the 3 most prominent. Some may see this history as an outrageous affront, as a form of intellectual colonialism, that the law of 21st century Africa should in fact be determined by the rights of 17th century Dutchmen. But the history that gave us the modern Roman Dutch law, private international law, is in my view generally beneficial. The fact is that those Roman Dutch writers were immensely influential, and I have in other writings traced their profound influence on English law, so that it's not too much of an exaggeration to say the foundations of English conflict of laws are Roman Dutch. The influence of the Roman Dutch writers was immense in the United States. The foundational writer on choice of law in the United States, Story, drew heavily upon the works of the Footes. And if you pick up a copy of Story's textbook written in 1834 and open it up at practically any page, you will find long quotations taken from those familiar names, Huber and Foote. I've barely touched upon the influence of the Roman Dutch writers in the development of conflict of laws on the continent of Europe. But the fact is that Ulrich Huber anticipated the Copernican revolution found in the writings of von Savigny, and inspired Tobias Asher, one of the leading lights and inspiring spirit of the Hague Conference, of which we have heard so much today. With a heritage of that kind, there is no need for anyone in Southern Africa to feel that their private international law is second-rate. We should be proud of those origins and their influence across the world. But now let us turn to the Hague Principles of Conflict of Laws. Now, I'm barely going to be able to touch on the salient features of the Hague Principles. They'll just be highlights. And in particular, I'm not going to say anything at all about the interesting concept, but completely unknown, new to Southern African law, of the battle of the forms and the rules of law as a choice in the exercise of party autonomy. But I am going to say something about party autonomy, probably the most important aspect of my presentation today. I regret, having said those wonderful things about our Roman Dutch heritage, to have to start by saying that Roman Dutch heritage is not distinguished on the subject of party autonomy. Johannes Foote and van der Keersel were the only two Roman Dutch writers who actually mentioned the choice of law of contract, and they rejected it. Prohibitory statutes, said Foote, could not be departed from by contract. Other writers were generally silent. Since the 17th century, since the 19th century and the 20th century in South Africa, there have of course been many cases that bristle with suggestions that the parties could choose the law governing their contract. And one might be inclined to think, well, that's settled then. Party autonomy is absolutely fine. But most recently, in 2010, in the representative of Lloyd's against Classic Sailing Adventures case, a peremptory norm of the forum was held not to be able to be excluded by a choice of the parties. And so the fact that the parties had chosen English law to govern a particular relationship did not prevent a rule of South African law determining the outcome of the dispute. Why is there this hesitation about party autonomy? A true choice of law clause is something quite remarkable, because the parties are choosing not the rules that they would like to govern a particular part of their contract, but are choosing the rules that actually determine whether they have a contract at all. And if it is a true choice of law, they will be excluding jus cogens or peremptory norms of the legal system that might otherwise be applicable. For instance, to think of an example, you might take a rule such as contracts for the sale of land have to be in writing. Can one, by the choice of a system of law to govern your contract, effectively avoid that provision by choosing a legal system that does not have that rule? The crucial issue with choice of law in contract is the choice of law strong enough to be able to exclude the peremptory norm of an otherwise applicable system? And there are logical difficulties with this. The essential point is this: what legal system governs the choice of law? What legal system governs the choice of law? It cannot be the chosen law, because the law has not yet been chosen. The law is only chosen if there has been a valid choice of law. So you cannot determine the validity of the choice of law by the chosen law. That is, said Professor Wouter de Vos some years ago, to try to pick the parties are trying to pick themselves up, juridically speaking, into the air with their own bootstraps. It's worth pausing here at the Hague Principles and to see that in Article 6 of the Hague Principles you will find a version of the bootstraps argument, in that there it is suggested that a choice of law can be tested, the validity of a choice of law can be tested by the law chosen. But it is a theoretical difficulty. Now, there are ways in which it can be overcome, and it has to be overcome, because the case for party autonomy is so incredibly strong. The case for party autonomy rests not upon these theoretical issues that I have been discussing with you, but rests upon the intense practical reasons why party autonomy should be adopted. And that practical reason has His Excellency Mr. Professor Berlusconi made absolutely plain, is legal certainty. So although we have a modern decision hostile to party autonomy, old authorities that don't adopt it, and no cases in which the issue has been crisply raised as to whether you can exclude the choice of peremptory norms that would otherwise be applicable, it's still an immensely strong and attractive case for party autonomy. And I think that if the issue were to become before a South African court, it would, crisply presented, properly placed before it, it would come to the conclusion that the parties had been able to choose the legal system governing their contract. And so, in the end, I come to the conclusion that there is no necessary contradiction or incongruity between the Article 2.1 of the Hague Principles, a contract is governed by the law chosen by the parties, and the modern Roman Dutch law. Can't say that that is cut and dried and is clear and crisp in decided cases or statute, but I think that is the position. The abiding appeal of party autonomy is the certainty that it brings. So much of our subject is uncertain, and we must therefore rejoice and seize certainty when we have that opportunity. I'm heartened by the fact that Fardil Adams, who I hope is here this afternoon, in his dissertation reaches a similar conclusion, that South African law is compatible with Article 2.1 of the Hague Convention, of the Hague Principles. At the very least, the Hague Principles therefore provide guidance to the development of our modern Roman Dutch law. And that is a heartening conclusion to be able to reach. And I think I've probably said enough about party autonomy. Now I want to say something about mandatory rules. And you may find it useful to have beside you a copy of the mandatory rules as we go along. I'm pleased, I can't remember which speaker it was earlier who said the two crucial points about the Hague Principles were party autonomy and the mandatory rules, and it looks as if I'm going to be able to deal with both of them. Let's deal with mandatory rules and have Article 11 by your side. The South African law on mandatory rules can be summed up in 4 propositions. Proposition 1. The local court will only apply the rules of a foreign legal system that may render the contract void or unenforceable if directed to do so by a choice of law rule. Okay, a local court will only apply the rules of a foreign legal system if directed to do so by a choice of law rule. Thus, it will not enforce a contract that is illegal under its proper law, even if it is not illegal under the lex fori. So if you enter into a gaming contract in a country in which gaming is illegal, and contracts made for gambling contracts are unenforceable and void, that statute or that provision will be enforced by the South African law if the applicable law to your contract is that of the foreign country, even if that contract would not be unlawful under South African law. So that's proposition 1. Proposition 2. The forum's rules may override the choice of law process, and they may render a contract illegal even if it's not illegal under its proper law. So you once more envisage a contract that is not illegal and it seems to be perfectly enforceable under its chosen law, but in fact there is an overriding provision of South African law that applies. If you sue in South Africa, so South Africa is the lex fori, then the South African law overrides and the contract is not enforceable. That's proposition 2. Proposition 3. Legal rules which are drawn from neither the proper law nor the lex fori are not applicable. Even if applied, they would render the contract illegal. For example, a contract that is illegal under its lex locis contractus is enforceable, provided it is legal under the proper law and the lex fori. This is not entirely crisply determined by the decided cases, but I think it's clear enough. Then finally, proposition 4. Public policy stands ever ready to ensure that the application of these rules does not lead to a result offensive to deeply held local principle. And there is one public policy rule that is characteristic of this area, and that is that it is contrary to public policy to enforce performance which is illegal under the law of the place of performance, the lex loci solutionis. Those 4 propositions sum up South African law in regard to mandatory rules. Put simply, other than where there's a result contrary to public policy, so public policy intervenes, the law is simply that mandatory rules from the lex fori are of course applicable, and mandatory rules from the proper law are applicable too. We were discussing at lunchtime, I can't remember who I was discussing it with now, what happened when you had mandatory rules from the forum and mandatory rules from the applicable law that contradicted each other. In those circumstances, it seems to be clear that the lex fori mandatory rules will override. In the end, the lex fori tends to be king in these areas. I'm going to skip over the academic writers in South Africa who do not entirely accept the position as I've stated it to be. I will mention them just. Schaeffer, whose writing is considered in my book in the 5th edition at page 348, who advocate, I started talking about them, so I might as well do that now, who advocate something like the Rome Convention rule, that the Rome Convention has, or that rule has been, the Rome Convention where one allowed discretionary application of a third-party rule if there was some connection between the contract and that third-party legal system rule. But that has been abandoned in the Rome regulation, so even Europe, where this idea initiated, seems to have dropped it. And Van Rooyen makes a similar point, and I don't think is a good point to make for similar reasons. Now let's look at Article 11. Proposition 1 and Article 11.1 are, it seems to me, essentially congruent. These principles shall not prevent a court from applying overriding mandatory rules of the law of the forum, which apply irrespective of the law chosen by the parties. That seems clear. Proposition 2 is consistent with Article 11.3. Proposition 2, I'll just remind you, is that the forum's rules may override the choice of law process and may render it illegal even if it's not illegal under its proper law. Proposition 2 is consistent with Article 11.3, or it is at least implied by Article 11.3. Proposition 3 is consistent with Article 11.2 about third-party mandatory rules. Although it should be noted the Hague principles allow the lex fori to adopt, on a discretionary basis, the application of rules of a third-party legal system, but they don't oblige it. And Proposition 4, which is of course the point about public policy, is recognized throughout Article 11. So, my overall conclusion in regard to mandatory rules is that there is little conflict between Article 11 and the relevant provisions of South African private international law. One may add that Article 11 rejects the approach of several European jurisdictions, including the Rome Convention and the Rome I regulation, of allowing judicial discretion to determine the application of the rules of a third party. Under the Rome Convention now, there is restriction to lex loci salutionis as the third party state and not otherwise. This is heartening and necessary for legal certainty, but the critical may note that Article 11.2 still allows such discretionary application where the lex fori so allows. I want to leave some time for questions to be asked. So I'm going to leave out my discussion of assignment, except to say this is the point at which I may be thought, and I have no desire to be thought so, I may be thought to be a bit critical of the Hague principles. But it does seem to me that the rules on assignment are verging into property. A debt owed by one person to another may be viewed as an asset. And in fact, there are many, many such assets in the world, and they are incredibly important. Certificates of deposits in banks, shares. These are incorporeal, movable pieces of property. They don't have a physical existence. They are property, but without corporate existence. And when you assign one from one person to another, such as when you transfer to another person by way of a check, for instance, your claim against the bank in which you have deposited funds, this is akin to a property transaction. After all, there are many aspects of property associated with such transactions. They can be, incorporeals can be pledged, they can be transferred, they can be sold. In other words, these are all things that happen to property. And the Hague Principles say they've got nothing to do with proprietary matters, but they simply deal with it as two contracts. A contract that creates the debt and a contract of an assignment that transfers it to another person. So far, so good. But is it really two contracts? When you look at the structure of Article 10, you will see that it specifies that many aspects of the assignment, the second contract, are in fact determined by the first contract, the contract that determined the debt. That is a mark, in my view, of the in rem aspect of property coming into play. So I wonder whether the assignment provisions, which are relatively similar to those in the Rome regulation, are really as good as they might be. As I don't wish to be critical, I may well be thought to say the Hague Convention made it perfectly plain in, I think, Article 1, Part 1E, that they were saying nothing about proprietary matters. But I think they should have. One final point that I want to make. Where does party autonomy come from? It's essentially a 19th century idea. It comes from a laissez-faire world, a world that consisted of individuals interacting with each other, capable of making contracts with each other, and this was believed, following the economic ideas of Adam Smith and others, as the best way of maximizing economic development and so forth in societies. Laissez-faire, where individuals were king. And that's what justifies allowing the individuals to choose even the law that is applicable to their contract. But we're not in the 19th century anymore. We're in a world where two individuals deal with each other. We're quite likely to ask, which is the stronger individual? Is the stronger individual dictating terms to the weaker individual? And this is a world which is ideologically more hostile to party autonomy than would otherwise be the case. You'll notice that the Hague Principles are limited to international commercial contracts, and they're specifically excluded quite a few matters of which consumer contracts and employment contracts are just the most obvious. It seems to me that the principles are wise. I wouldn't necessarily say every aspect of their definition is right, but the principles are wise to restrict themselves to international contracts, international commercial contracts, thinking no doubt, arguing no doubt, that international commercial parties are more like equals dealing with each other, not needing to protect the weaker party. And I think legal certainty is so important that that's probably justified. But I can't avoid making this point, that international commercial contracts do not always have two equal parties on either side of them. If you are, say, a franchisee dealing with a franchisor from abroad. You will be a small business seeking to become a medium-sized business. The franchisor may be a mega business seeking to maximize its profits. It's an international commercial contract on the definition that would be given in the Hague Principles, but it's one in which the parties aren't on equal standing. I think a lot of that inequality might have to be tolerated because of the benefits of certainty that align choice to the choice of the parties to prevail. But it is a conceptual difficulty with this area. I'd also make a final practical point. A lot of the certainty that is achieved by recognizing party autonomy is lost if you then get into a long, complicated dispute over whether this was in fact an international commercial contract or not. And that would be a pity if the certainty brought by party autonomy is then substantially undermined by the definition of an international commercial contract. So there are some points on which I hope in a beneficent and helpful manner I have made about the Hague Principles, but on the crucial points, party autonomy, with some hesitation, I think modern Roman Dutch law is compatible with that, and mandatory rules, similar compatibility. I will stop in, I hope, relatively early, so there will be time for questions. Thank you all very much.
Without any waste of time, ladies and gentlemen, Your Excellencies, ladies and gentlemen, I wish to invite the next speaker. Our next speaker is Adv EA Fredericks. Adv Fredericks is the head of the Department of Practical Business Law at the Soweto campus of the University of Johannesburg. He specializes in the field of private international law and is the Deputy Director of the Research Center for Private International Law in Emerging Economies at UJ. Adv Fredericks is also a member of the working group of the Judgments Project of the Hague Conference on Private International Law. Adv Fredericks will be addressing us on the theme or the topic, the Research Center for Private International Law in Emerging Countries at UJ.
I stand here actually quite relieved, I must tell you. I don't know if many of you are aware, Prof George actually came in with a clock. He literally came in with some kind of timing clock. So, I mean, that, as far as timing is concerned, he gave it back. It's not a problem, and I think as far as it's concerned. It's my ardent intention to meet every one of the delegation on both sides. You know, from the courts of the International Court of Justice, the Hague as well. But obviously, for purposes of my talk this afternoon, I'm Adv Fredericks, and Your Excellencies, ladies and gentlemen, I was asked to introduce you to the Research Center for Private International Law in Emerging Countries. The Research Center is part of the Faculty of Law at the University of Johannesburg, which is the only African institute admitted to the prestigious U21 network of universities involved in progressive strategic thinking on issues of global significance. The faculty has the highest per capita research output, as you may have heard a little earlier on from the talk this morning. The highest per capita research output in the university, and according to the QS World University Subject Rating for 2013-2014, is the 4th highest rated law faculty in Africa, and between numbers 13 and 14 in all BRICS countries. The faculty has cooperation agreements with various other law faculties such as Belgium, China, Germany, Iceland, India, Kenya, Malawi, the Netherlands, and of course in Turkey. The faculty also accommodates the Regional Information Center for the Hague Conference on Private International Law, a familiar sight. A cooperation agreement in this regard was concluded some 7 years ago, and today's conference is one of the tangible results of the long-standing agreement. The faculty highly appreciates the involvement of the Hague Conference with the University of Johannesburg and looks forward to expanding relations with the International Court of Justice and the Permanent Court of Arbitration. Another familiar site. The Research Center was established in 2001 by Professor JL Neels with the enthusiastic support of Professor Adv Mpedi, whom I have seen a little earlier on, who was then the Dean of the Faculty of Law and who later became the Pro-Vice Chancellor of the university. The establishment of the center was partially inspired by a paper of Professor Andre Thomas-Hausen entitled, or from UNISA at least, entitled Private International Law in Africa. And this paper was delivered right here at the University of Johannesburg way back in August 2000. Another familiar face. From the beginning, the Centre could always count on the support of Professor Christopher Forsyth of Cambridge University. And so, Professors van der Merwe, Thomas-Hausen, and Forsyth, today you indeed deserve our applause. Numerous I see Forsyth frowning there a little. Numerous publications have been produced by the Centre, published, amongst others, Belgium, Germany, the Netherlands, Paraguay, South Africa, Switzerland, Turkey, and of course the United Kingdom. The research focus has been on commercial, private international law of contract and private international law in a multicultural context. All research associated with the Research Center is widely comparative, involving common law, civil law, and mixed jurisdictions, established and emerging countries, and national, regional, supranational, and international instruments. There is indeed also a particular focus, and that is on the contributions and needs of legal systems of emerging countries, including but not limited to member countries of the African Union and BRICS. A focus on emerging countries has usually been absent from the scientific or international scientific debate. However, during 2013, I think you've heard that before also a little earlier on this morning, Africa was the continent with the highest percentage of economic growth. The latest International Monetary Fund projection, as you can see right there, predicts a growth rate of 6.1% in 2014 for sub-Saharan African economies alone. And this is trumped only by China with 7.5%. The BRICS countries of Brazil, Russia, India, China, and South Africa account for 43% of the world's population and 18% of world trade. They attract 53% of all foreign capital and produce 45% of growth in the world economy, and of course 25% of global GDP on purchasing power parity based. That's it. Intra-BRICS, the trade increased with an average of 28% per annum since 2001. BRICS is therefore an important role player in international trade, and the African Union is the next big story waiting to happen. The Research Centre has therefore launched a project under the umbrella name of the African Principles on Commercial Private International Law. We will undertake comparative research and of established and emerging systems of commercial private international law to provide systems of to provide economic integration organizations such as the African Union with various models which may be integrated into domestic law or even regional laws. The envisaged models may be provisionally called, in the first place, the African Principles on the Law Applicable to International Contracts of Sale. More generally, the African Principles on the Law Applicable to International Commercial Contracts. In the third place, the African Principles on the Recognition and Enforcement of Foreign Judgments. And lastly, the African Principles on Jurisdiction in International Civil and Commercial Cases. You can see the caption right on the top, and that is exactly the importance of it all. The existence of a reliable and sophisticated transnational legal infrastructure in respect of international commercial law, and specifically commercially private international law, is a prerequisite for inclusive economic growth. It is hoped that the African Principles will make a contribution to increasing foreign investment, economic development, and ultimately the alleviation of poverty on the African continent. Some more information about the other projects produced by the research project or underway of the Research Centre. Of course, it arranged numerous national and international seminars and workshops, as well as 4 major international conferences on comparative private international law. The Centre submitted various reports to the South African Law Reform Commission on the national and international recognition of foreign marriages, of religious marriages, I beg your pardon. Reports were also submitted to the European Commission on the revision of Rome Convention on the law applicable to contractual obligations, the International Association on Procedural Law and the International Academy of Comparative Law on International Consumer Protection. The Research Centre was also involved in projects with the Women's Legal Centre in Cape Town, the Global Sales Law Project of the University of Basel, the Hague Academy of International Law, and the Hague Conference on Private International Law, more specifically, of course, the Working Group and the Special Commission on Choice of Law in International Contracts, and the Expert Group of the Judgments Project. The UJ Law Library was recently appointed as a repository for the UNIDROIT documentation, and the Centre will also, of course, be involved in the introduction of UNIDROIT instruments on the African continent. The Centre also contributes to the conflictsoflaws.net, an open access electronic information system on private international law based at the University of Birmingham. It has come to our attention that many electronic reported decisions of courts in emerging jurisdictions are not systematized by academics. An initiative to help remedy the situation commenced earlier on in 2014. Countries involved will of course be South Africa, it's not listed there, but of course South Africa, and its neighboring countries, Botswana, Lesotho, Namibia, Swaziland, and Zimbabwe, as well as, of course, Sri Lanka, which all share the same common law, a mixture of Roman Dutch and English law. Something I think Professor Forsyth said a little earlier on as well. We may perhaps extend this program to India, Kenya, Malawi, and Nigeria. The Research Centre is also responsible for the LLM program in International Commercial Law, the flagship program of the Faculty of Law, and which is now attended by students from various countries in Africa, Europe, and the Far East. The different modules approach the topics on various national and regional, on the supranational, and on the international level. The wide comparative approach includes the supranational instruments or national legal systems of South Africa's most important partners, namely the European Union, China, Japan, the United States, and India. Of course, also the important African trading partners, which include our neighbors and Kenya and Nigeria. Also, obviously, in this category are all the BRICS countries and other important role players as Australia, Canada, South Korea, Switzerland, and again Turkey. So, in 2010, the center I joined the center, and as time went on, I became the deputy director. But then again, at the beginning of 2014, the research center was joined by some research associates. Now, I must just say that I was cautioned by some colleagues that these are not their best photographs. But I beg to differ. I beg to differ on that particular point. The research associates are Ms. Enid Kutsia. I've seen her here. I see her at the back. Thank you, Enid. Ms. Robin Cupido, sitting right in front, as you can see there as well. Nasreen Ismail, Mr. Fadil Adams, and Mr. Garth Bowers, and, of course, Mr. Rudy Cook. So, this is Your Excellencies, ladies and gentlemen, we hope that these new developments may usher in a renaissance of the academic study of private international law in South Africa and in Africa in general for the benefit of future generations. And that was all I wanted to say.
Your Excellencies, ladies and gentlemen, I'd like to speak about two of the proposed sets of African principles of commercial private international law, namely these dealing with international contracts of sale, or the law applicable to these contracts, and the law applicable to international commercial contracts. These sets of principles are intended to become model laws on the national, but especially on the regional level, preferably to be endorsed by the African Union. Now, the African Union has indeed expressed interest in our project, and the very efficient office of the Chief State Law Advisor, International Law, of the South African Department of International Relations and Cooperation will be requested to facilitate via the South African Mission in Addis Ababa the request for formal endorsement of the project by the African Union. Now, of course, a full-scale consultation process will have to take place, and the following and therefore only my preliminary or our preliminary ideas of how the relevant African principles could be structured. Now, in as far as choice of law properly so-called is concerned, the African principles under discussion will probably fully incorporate the Hague principles as the recognition of party autonomy in the sphere of international commerce meets the legitimate expectations of the parties involved in this environment and therefore advances foreseeability and legal certainty. But what about the applicable law in the absence of a choice in this regard? Now, the preliminary design for the African principles here entails the fusion in a private international context of both conflicts law and substantive law. If I can go back in history for some time, already Bartolus de Sexoferato in the 14th century made use of the mediating role of the jus commune in the triangulatory interpretation of conflicting laws of competing jurisdictions. Now, in postmodern times, this concept has re-entered legal theory, foremost in the form of the teleological substantive law approach to private international law of the late German-American Professor Fritz Junger, who was, of course, the main architect of the Mexico City Convention of 1994. Now, this convention only entered positive conflicts law in two South American countries, Mexico and Venezuela, but it has been an inspirational model on the academic level ever since. Its prime innovative provision is to be found in Article 9, which determines that in the absence of a choice of law, the law of closest connection applies, nothing surprising there. But then it adds, the court shall also take into account the general principles of international commercial law. General principles of international commercial law recognized by international organizations. Now, the effect of this provision is a rather uncomfortable marriage of a civilian and a substantive law approach. And so much was admitted by Professor Junge himself, but he expected the reference to international commercial law to be the more influential one in due course. The problem is, of course, that in the interim, there will be serious legal uncertainty. Nevertheless, the idea behind this provision is convincing, namely that the application of an internationally recognized body of contract law would be preferable to the application of a national legal system in this regard, which may be difficult to determine, it may be outdated, it may be unsophisticated, it may be ill-adapted to international commerce. But what should take the place of the national legal system? I would suggest that the UNIDROIT principles of international commercial contracts would be the ideal candidate. These principles are obviously of a high quality, clearly sophisticated, formulated by an intergovernmental organization, readily accessible on the internet, together with all relevant case law and academic commentaries abound. The principles mirror current best practice and, very important, are kept up to date on a regular basis. I would therefore propose that in both the African instruments that we're discussing now, these on choice of law, in the absence of a choice of law, the UNIDROIT principles would ex lege be applicable. Now, the preamble itself, of course, suggests this possibility, and it was also in the mind of Professor Junge when drafting the Mexico City Convention. Other contemporary constructions also make use of the UNIDROIT principle in a private international law context. For instance, the German author Leitner, but only in the context of international commercial arbitration. There's also the interesting work of the Indonesian author Hadjo Bahono and his idea for an ASEAN convention. ASEAN, as you know, is the Association of Southeast Asian Nations. ASEAN Convention on the applicable law in transnational commercial contracts. But he would only employ the principles as an alternative solution in the event that the application of the law of closest connection would lead to a result in conflict with justice and equity. Now, this construction may lead to a high degree of uncertainty, similar to that under the Mexico City Convention. We would rather have the UNIDROIT principles be employed without competition of national legal rules indicated by a civilian framework. Now, having an international soft law codification at its heart, of course, leads to particular drafting problems for the African principles in respect of, for instance, mandatory rules, public policy, prescription, limitation. There also needs to be an internationality provision and one for gap filling. Now, leaving the possibility of the application of the CISG aside for the moment, which national legal system should apply if the UNIDROIT principles do not make provision for the particular situation? Now, private international law reformers worldwide now opt for constructions based on either the Rome Convention or the Rome I regulation on the law applicable to contractual obligations, which is in force in member countries of the European Union. Examples of the global influence of the Rome model, be it the convention or the regulation, may be found from Russia to South Korea, from Turkey to Japan, and from Quebec via Tunisia to China. The Australian Law Reform Commission and South African authors as Forsyth and Fredericks are also in favour of development along these lines. The global acceptance of the Rome model makes it interesting also from the point of view of international harmony of decision and the eradication of forum shopping. Also, the Rome model is relatively straightforward, user-friendly, and of course it's available in codified form. Perhaps, therefore, the gap-filling provision in the African principles may be modeled after the Rome 1 regulation. The African principles under construction have many sources of inspiration and entail a relatively novel fusion of various models, including these advocated by Bartolus, by Juncker, Leitner, Hachewahana, and instruments as the Hague Principles, the Mexico City Convention, Rome 1, the Planté-Zion Convention, and the Unitwa Principles. Your Excellencies, and as we know it from, Your Excellencies, ladies and gentlemen, as you can see, and as we know it from Plinius the Elder himself, Ex Africa semper aliquid novi, there's always something new coming out of Africa. I thank you for your attention.